The letter arrived on a Tuesday, but Maria Esperanza didn't open it until Thursday. She'd learned to wait. In 23 years of living in America, she'd learned that bad news doesn't spoil. It keeps. And something about the county seal in the corner, the way it sat crooked on the envelope like it had been stamped in a hurry, told her this wasn't good. She was right. The letter informed her that her home, the three-bedroom house on Sycamore Lane in Madera, California, the house she'd paid a mortgage on for 19 years, the house where she'd raised 2 sons and buried a husband, was scheduled for demolition in 90 days. Eminent domain. The county needed the land for a drainage expansion project. They'd sent notices, the letter claimed. 3 of them. Maria had never seen a single one. She called the number at the bottom of the page. A woman with a tired voice told her the decision was final. The compensation check, already calculated, was for $61,000. Maria's house was worth 3 times that. She'd had it appraised just 2 years ago when she refinanced to pay for her son Gabriel's community college. The woman on the phone said she could file an appeal if she wanted. The deadline was in 4 days. The office closed at 3. Maria Esperanza was 62 years old. She worked the early shift at a commercial laundry facility in Fresno, folding hotel sheets for $11.40 an hour. She didn't have a lawyer. She didn't have savings. She had a house that someone had decided to take and a clock that had already started ticking. She hung up the phone and sat at her kitchen table for a very long time. What she didn't know, what she wouldn't learn for another 3 months, was that her name was not the only one on that list. There were 14 other properties marked for acquisition along the same 6-block corridor. 12 of them were owned by Latino families. 11 of those families had never received proper notice either, and the drainage project the county claimed was urgent had been shelved twice in the past decade for lack of funding. It had only been revived 6 weeks ago, right after a commercial development group called Terravance Partners began quietly purchasing land 2 blocks north of the demolition zone. But Maria didn't know any of that yet. All she knew was that her house, the only thing she owned in this world, was about to be erased. She went to the county office the next morning. She took the bus because her car had a check engine light she couldn't afford to investigate. She arrived at 8:15. The office didn't open until 9. By 9:40 she was still waiting. A man behind the counter finally called her forward at 10:12, looked at her letter, looked at her, and said she needed to file a Form 7C for appeals, but they were out of copies. She could come back tomorrow. Maria came back the next day. They had the forms. She filled them out by hand, slowly, carefully, terrified of making a mistake that would invalidate everything. A clerk took the forms without looking at them and told her she'd receive a hearing date in the mail. Maria asked how long that would take. The clerk shrugged. Maybe 3 weeks, maybe 6. It depended on the docket. Maria had 90 days, now 87. She went home and called her son Gabriel, the one who'd finished 2 years of community college before dropping out to work construction. Gabriel was 24 years old and angry about most things, but especially about things that happened to his mother. He came over that night with his laptop and started searching. What he found didn't make sense. The drainage project had no active environmental review on file. The acquisition letters referenced a county ordinance that didn't exist, and the compensation offer of $61,000 was based on a property assessment from 2016, not the current market value. Gabriel wasn't a lawyer, but he'd taken a business law class. He knew enough to know this was wrong. He also knew that being right didn't matter if you couldn't prove it in front of someone who cared. He called a legal aid office the next morning. They told him their housing attorney had a 3-month wait list. He called a civil rights organization in Fresno. They said eminent domain cases were outside their scope. He called a private attorney whose name he found on a billboard near the highway. The attorney's receptionist asked if they could afford a $5,000 retainer. Gabriel said no. The receptionist said she was very sorry and wished them luck. On day 81, Maria received her hearing date. It was scheduled for day 93. 3 days after her house was supposed to be gone. Gabriel drove to the county office himself this time. He waited in line for an hour. When he reached the counter, he explained the problem. The clerk checked the system and said the hearing date was correct. Gabriel said that didn't make sense. The clerk said he could file a motion to expedite. Gabriel asked for the form. The clerk said they didn't have that form at this location. He'd need to go to the main courthouse in Fresno. Gabriel went to Fresno. The courthouse said the motion needed to be filed with the original department. Gabriel explained that the original department didn't have the form. The clerk in Fresno looked at him for a long moment, then said, "I don't know what to tell you." Gabriel stood there in the marble lobby of the Fresno County Courthouse and felt something crack inside him. Not break, not yet, just crack, a fissure that would grow. He went home and told his mother they needed help, real help, someone who knew how to fight. That night he posted the story on a community Facebook group for Madera residents. He didn't expect much. He just needed to do something, anything, that felt like action. By morning, the post had 200 comments. One of them was from a woman named Linda Fong. She said her aunt lived on Sycamore Lane 2, 4 houses down from Maria. She'd received a similar letter. She hadn't opened it yet because she'd been in the hospital. Another comment was from a man named David Herrera. He said his parents were on the list. They were in their 70s. They didn't speak English. They hadn't understood the letter at all. Gabriel started making calls. By the end of the week, he had 11 families, 11 houses, 11 letters with the same language, the same deadlines, the same compensation offers that seemed calculated to lowball everyone just enough to avoid suspicion. He also had a name he kept seeing in the county records, Terravant's Partners. Gabriel didn't know who they were, but he knew they'd bought 6 parcels of land in the past 4 months, all within a quarter mile of the demolition zone. And he knew that one of the county supervisors, a man named Donald Kretschmer, had received a campaign contribution of $12,000 from a company called TVP Holdings, LLC. TVP Holdings, Terravant's Partners. Gabriel wasn't a conspiracy theorist. He wasn't even particularly political, but he understood how power worked. He'd grown up watching it work against his mother, against his neighbors, against everyone who looked like them and talked like them and worked the jobs no one else wanted. And now he understood that this wasn't a drainage project. This was a land grab. He needed a lawyer, not a legal aid attorney with a 3-month wait list, not a billboard lawyer who wanted $5,000 up front. He needed someone who would fight, someone who knew how to make noise. He found her on page 4 of a Google search, buried between sponsored ads and outdated directory listings. Her name was Priscilla Navarro. She was 41 years old, operated a solo practice out of a converted garage in Clovis, and specialized in what she called impossible cases. Her website was ugly. Her testimonials were sparse, but one of them caught Gabriel's eye. It was from a family in Tulare County who'd been facing eviction from a mobile home park. The park owner had tried to sell the land to a developer. Priscilla Navarro had blocked the sale for 18 months and eventually negotiated a buyout that let every resident relocate with compensation. Gabriel called her that afternoon. She answered on the second ring. Her voice was flat, direct, and tired in a way that suggested she'd heard a lot of stories like this. Gabriel told her everything: the letters, the fake ordinance, the outdated assessments, the hearing date that came after the demolition deadline, the county supervisor and his campaign contributions, the 11 families who didn't know what to do. Priscilla was quiet for a long moment. Then she said, "How soon can you get everyone in one room?" 3 days later, Maria Esperanza's living room was full. There were 11 families, 26 people total, sitting on folding chairs and couch cushions and the floor. Some of them had brought documents. Some had brought food. One elderly woman had brought her rosary and held it the entire time, lips moving silently. Priscilla Navarro stood at the front of the room with a whiteboard she'd brought herself. She didn't waste time with introductions. She didn't offer comfort or reassurance. She just started talking. "Here's what I know," she said. "The county is using eminent domain to acquire your properties for a drainage project that has no current funding, no environmental review, and no public comment period. The notices they claim to have sent were either never mailed or deliberately misdirected. The compensation offers are based on assessments that are 7 years out of date. And the hearing schedule has been structured in a way that makes it nearly impossible for you to challenge the process before the demolition begins." She let that sit. "Here's what I suspect," she continued. "The drainage project is a pretext. The real goal is to clear this land for private development. A company called Terravance Partners has been buying adjacent properties for months. They've made campaign contributions to at least one county supervisor. And the timing of this acquisition push coincides almost exactly with their purchase activity." The room was silent. "Here's what I can do," Priscilla said. "I can file a lawsuit on behalf of all of you, challenging the legality of the eminent domain process. I can request an emergency injunction to halt the demolitions until the case is heard. I can subpoena county records to prove the notices were never sent. And I can depose the officials responsible for this decision to find out exactly who knew what and when." She paused. "Here's what I can't do. I can't guarantee we'll win. I can't guarantee the injunction will be granted. I can't guarantee the court will care. Eminent domain cases are hard. The government has enormous latitude, and judges in this county have historically sided with development interests." She looked around the room. "I'm also going to be honest with you about money. I don't have the resources to take this case on contingency. I need a retainer, not $5,000 per family, but something, whatever you can manage. Because if we're going to fight, I need to be able to pay for depositions, subpoenas, expert witnesses, and my own time." An older man in the back raised his hand. His name was Rogelio Cruz. He'd been a farm worker for 40 years before his back gave out. He said, "How much?" Priscilla said, "20,000 total, split however you want." The room stirred. $20,000 was a fortune to most of them. It was also, Maria realized, about a third of what the county was offering her for her house. She stood up. "I'll put in 5,000, she said. "From the compensation money. If they're going to take my home, they can pay for me to fight back." Other voices followed. 2,000 here, 1,500 there. David Herrera's parents offered $800, everything they'd saved for their anniversary trip to Guadalajara. By the end of the night, they had $19,200. Priscilla Navarro accepted it. The lawsuit was filed 4 days later. It named Madera County, the County Board of Supervisors, the Director of Public Works, and, as a party of interest, Terravance Partners. The complaint alleged procedural violations under California's eminent domain statutes, due process violations under the 14th Amendment, and a civil rights claim under Section 1983 for discriminatory targeting of Latino homeowners. The county's response came within 48 hours. They denied everything. They also filed a motion to dismiss, arguing that the plaintiffs had failed to exhaust administrative remedies, that the lawsuit was premature, and that the claims were speculative and inflammatory. The motion was assigned to a judge named Harold Wexler. He was 68 years old, a former prosecutor, and had been on the bench for 22 years. His record on property rights cases was mixed. His record on civil rights cases was not. Priscilla filed an opposition brief. She also filed her emergency motion for injunctive relief, asking the court to halt all demolitions until the case could be heard on the merits. The hearing was set for day 88, 2 days before the demolition deadline. Maria Esperanza didn't sleep the night before the hearing. She lay in her bed, in the room she'd shared with her husband until he died, and stared at the ceiling. She thought about the first time she'd seen this house. She'd been 39 years old, newly widowed, with 2 boys under 10 and a job that paid just enough to qualify for a mortgage. The real estate agent had called it a starter home. Maria had called it a miracle. She thought about the lemon tree in the backyard that her husband had planted the first spring. It still produced fruit. She gave bags of lemons to her neighbors every January. She thought about the water stain on the living room ceiling from the year the roof leaked. She'd never fixed it. It looked like a map of a country that didn't exist. She thought about what it would mean to lose all of this. Not just the house, the proof that she had been here, that she had built something, that her life had mattered. In the morning, she put on her best dress and went to court. The Madera County Superior Court was a beige building that looked like a community college. The courtroom itself was smaller than Maria expected. There were no cameras, no crowd, just the lawyers, the judge, and a handful of family members who'd come to watch. Judge Wexler entered at 9:15. He was a tall man with white hair and a face that revealed nothing. He sat down, adjusted his glasses, and began reading from the case file as if he'd never seen it before. The county's attorney spoke first. His name was Martin Halpern. He was from a firm in Fresno that specialized in municipal defense. He argued that the eminent domain process had been conducted properly, that all required notices had been sent, and that the plaintiff's claims were based on speculation and hearsay. He said the county had a legitimate public interest in the drainage project, and that delaying it would cause harm to the community. Priscilla Navarro spoke second. She didn't raise her voice. She didn't make dramatic gestures. She simply laid out the facts. The notices had not been received. The ordinance cited in the acquisition letters did not exist. The compensation offers were based on outdated assessments. The hearing schedule had been structured to make legal challenge impossible, and the timing of the acquisitions coincided precisely with Terravant's partners' land purchases. "This is not eminent domain," Priscilla said. "This is expropriation by design. The county is not taking these homes for public use. It is taking them for private profit, and it is targeting a specific community because it believes that community will not fight back." She paused. "These families are fighting back." Judge Wexler listened without expression. When Priscilla finished, he asked a single question. "Counsel, do you have evidence that the notices were not sent, or merely that they were not received?" Priscilla hesitated. It was a crucial distinction. The county had produced mailing records showing the notices had been generated, but the records didn't prove the notices had actually been mailed, and there was no tracking, no return receipts, nothing. "Your Honor," she said, "the county's records show only that the notices were printed. They do not show they were mailed. And the fact that 11 separate households, all on the same street, all failed to receive them suggests either a systemic failure or deliberate suppression." "Suggests," Judge Wexler said, "but does not prove." Martin Halpern jumped in. "Your Honor, the county followed standard mailing procedures. The plaintiff's speculation about what may or may not have happened is insufficient to overcome the presumption of regularity." Judge Wexler nodded slowly. Then he issued his ruling. He denied the motion for injunctive relief. He said the plaintiffs had not demonstrated a likelihood of success on the merits. He said the county's procedures, while imperfect, were not clearly unlawful. He said the public interest in the drainage project outweighed the private interest of the homeowners. He said the demolitions could proceed as scheduled. Maria Esperanza sat in the gallery and felt the ground fall away beneath her. She didn't cry, she didn't move. She just sat there very still as the courtroom emptied around her. Priscilla found her in the hallway afterward. "It's not over," Priscilla said. Maria shook her head. "They're going to take my house." "Maybe, but not yet. I'm filing an emergency appeal, and I'm going to the press." Maria looked at her. The press. This story deserves to be told. If we can get enough attention, enough pressure, we might be able to slow them down, buy more time, maybe even get the case heard before they can act. Maria thought about what that would mean. Cameras, reporters, her face on the news, her story laid bare for strangers to judge. She thought about her husband, who had always said that silence was safer, that you didn't make waves, that you kept your head down and worked hard and hoped the world wouldn't notice you. She thought about how well that had worked. "Do it," she said. 2 days later, a reporter from the Fresno Bee came to Sycamore Lane. Her name was Rachel Denton. She was 34, a graduate of UC Berkeley, and had covered local government for 6 years. She'd heard about the lawsuit through a source in the courthouse. She'd been skeptical at first. Eminent domain stories were common. They rarely went anywhere. But when she saw the documents Gabriel had assembled, her skepticism faded. She interviewed Maria. She interviewed David Herrera's parents through a translator. She interviewed Priscilla Navarro, who laid out the case with the calm precision of someone who had nothing to hide. And then she started making calls to the county. The county declined to comment. She called Terravant's partners. They also declined to comment. She filed a public records request for all communications between the county and Terravant's partners related to the drainage project. The county said it would take 60 days to process. She filed a second request for Supervisor Kretschmer's calendar and meeting logs. The county said those records were exempt from disclosure under executive privilege. She published the story anyway. It ran on a Sunday above the fold. The headline read, "Matter families face eviction as questions swirl over land deal." The story laid out everything. The notices that were never received, the ordinance that didn't exist, the outdated assessments, the campaign contributions, the timing of Terravance's purchases, the judge who denied the injunction. It quoted Maria Esperanza, "They want us to disappear, like we were never here." By Monday morning, the story had been picked up by the Los Angeles Times. By Tuesday, it was on CNN. By Wednesday, Supervisor Kretschmer had announced he was recusing himself from all matters related to the drainage project. And by Thursday, the county quietly filed a motion to stay the demolitions pending further review. The demolitions did not happen on day 90. They did not happen at all. Over the next 6 months, the lawsuit wound its way through the courts. Priscilla Navarro took depositions from county officials, uncovering a paper trail that showed the drainage project had been fast-tracked without proper environmental review. She subpoenaed emails between Terravant's partners and the county's Economic Development Office, revealing conversations about land availability that predated the official acquisition process by nearly a year. She also discovered something that changed everything. The mailing records the county had produced at the hearing were incomplete. A clerk in the Public Works Department, facing a deposition she couldn't avoid, admitted that the notices had been printed but never actually entered into the postal system. A processing error, she called it. A mistake. Priscilla didn't believe in mistakes. Neither did the Ninth Circuit Court of Appeals. In a ruling issued 14 months after the original lawsuit was filed, the court found that the county had violated the due process rights of the homeowners by failing to provide adequate notice. It found that the eminent domain process had been procedurally defective and substantively questionable, and it remanded the case for a new hearing, with instructions to the lower court to consider evidence of discriminatory intent. The county settled 3 weeks later. The terms were not made public, but Gabriel Esperanza knew the numbers. Each family received fair market value for their homes, plus relocation assistance, plus damages. Maria received $214,000. She used some of it to pay off her mortgage. She used some of it to put Gabriel back in school. She used the rest to buy a smaller house in Clovis, closer to her grandchildren. The house on Sycamore Lane still stood. The drainage project was never built. Teravant's partners quietly withdrew from Madera County. Their plans for a mixed-use development were never announced, never approved, never realized. Supervisor Kretschmer did not run for re-election. Judge Wexler retired the following year. Priscilla Navarro went back to her converted garage in Clovis and took on another impossible case. And Maria Esperanza, now 64 years old, sat on the porch of her new house on a Thursday morning, 2 years after she'd opened that letter with the crooked county seal, and watched the sun come up over the Central Valley. She still had the letter. She'd kept it in a drawer, folded into thirds, next to her husband's death certificate and her citizenship papers. She didn't know why she'd kept it. Maybe as proof, maybe as a reminder. Maybe because some wounds need to stay visible, so they don't get forgotten. Her phone buzzed. It was Gabriel texting to say he'd passed his midterms. He was studying public administration now. He wanted to work for a city someday. A real city, he said, one that didn't eat its own people. Maria smiled. She typed back a heart emoji, then deleted it. She typed, "I'm proud of you," instead. She put the phone down and looked out at the street. A woman was walking by with a stroller. A man was trimming his hedge. A dog was barking somewhere in the distance. Ordinary things, ordinary morning. She thought about Sycamore Lane. She thought about the lemon tree, which was still there, still producing fruit every January, even though no one lived in the house anymore. She'd driven by a few months ago just to see. The yard was overgrown. The windows were dark, but the tree was blooming. She thought about the water stain on the ceiling that looked like a map of a country that didn't exist. She thought about the night she'd stood in that room and told a room full of strangers that she would give $5,000 to fight for something she might lose anyway. She thought about what it had cost her, what it had cost all of them. And she thought about the letter, the one that had arrived on a Tuesday, the one she hadn't opened until Thursday. She wondered sometimes what would have happened if she'd opened it that first day. Would she have fought harder? Would she have given up sooner? Would the extra 48 hours have changed anything at all? She didn't know. But she knew this. The letter had been designed to make her disappear, to make all of them disappear, to erase their homes, their histories, their proof of existence, and replace it with something cleaner, newer, more profitable. It hadn't worked. They were still here. And somewhere in a drawer in a house in Clovis, that letter was still folded into thirds, still waiting, still proof that someone had tried to bury them. And they had refused to stay buried. Maria finished her coffee. She went inside. She had a doctor's appointment at 10 and a lunch date with her younger son at noon. She had a life to live. But before she left, she stopped by the drawer. She didn't open it. She just touched the handle, just rested her fingers there for a moment. Then she walked out into the morning, into the light, into the world that had tried to forget her. And she remembered everything.